stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static with Mark Chenoweth and John Vecchione. We are joined by another one of our litigation colleagues, litigation counsel Shang Li, who has been leading the effort for NCLA in a lawsuit against the Department of Education over a discriminatory rule that the department has been using for many years now in its decision on how to award Fulbright-Hays Doctoral Dissertation Research Abroad Fellowships. And I'm pleased to say, and congratulations to you, Shang, pleased to say that the Federal District Court has granted an injunction to a preliminary injunction to NCLA. Can you tell us about this recent development in the case and sort of where things stand? Welcome to the program.
Thank you, Mark, and definitely happy to talk about this case. So just a little table setting and background.
Actually, while I'm thinking about it, Shang, I should say this case was featured on the front page of the New York Times just here in the last week or so. So this is a big case. Yeah.
So in the 1960s, when the United States was in the midst of the Cold War, Congress enacted the Fulbright-Hays Act to help basically the United States develop a better diplomatic corps. The idea is to train U.S. students, doctoral students, to go overseas and conduct dissertation research in a foreign language. And so the act was, promulgated and it directs the Department of Education to award these fellowships to graduate students and doctoral students to promote their foreign language training. And for many decades, the department, administers this act, and it interpreted foreign language to mean any non-English language without regard to where the applicant's from. So, I was born in China and I grew up speaking Chinese as a native language, but if I could use this to study in China and that would be no problem. But in 1998, the department issued a regulation and it reinterpreted what foreign language meant. And it said that you can't, to qualify for the fellowship, you normally need foreign language proficiency, but to meet that requirement, you can't use your native language. Meaning someone like me, if Chinese were my native language, I wouldn't be able to study in China because they speak Chinese there. So that was a major change. And fast forward to today, and we have
25 years later.
Yeah, about 20 some years later, no one's challenged this thing. And we have a couple clients where, for example, someone born in Kuwait who wanted to study in Jordan. So her native language is Arabic, and so she couldn't use her native Arabic language to study in an Arabic-speaking country. We also have a U.S.-born client who grew up, children of immigrants who spoke Spanish, so she learned Spanish at home and is considered a native speaker of Spanish, and she wanted to study abroad in Mexico, which speaks Spanish, so she couldn't use her Spanish language proficiency to meet that requirement. And that inability to use that native language essentially disqualified them from getting the award, and they were both denied. So we represented these clients and challenged the department's regulation, arguing two arguments. First, we said it was discriminatory, violating their due process rights because discriminating based on someone's native language it's the same as discriminating based on their national origin. And our second argument is statutory, arguing that the term modern foreign language in the Fulbright-Hays Act means any non-English language as opposed to a non-native language that the department interpreted.
Right. So did the judge reach both of these issues or not in motion for preliminary?
No, typically a lot of courts will do what's called constitutional avoidance, and they'll rule on the statutory or the procedural issue without touching the constitutional issue. That's precisely what the judge did. It looked at the statute, which says you have to promote modern foreign language and training and said, well, what does foreign language mean? And under our interpretation, foreign language just means any non-English language, because the word foreign should be, the perspective should be with respect to the country in which a language is indigenous. The department, however, came up with its own definition and said, well, actually, they contend that foreign should be, that word should be interpreted with respect to the individual applicant. That is to say, a language is foreign if it's not, if it's, it depends on if it's foreign to the applicant. So if you grew up speaking Spanish, Spanish is not foreign to you, and therefore it's not a foreign language that the department is trying
to encourage you to study.
Exactly. And
right.
And so interestingly, the department invoked what's called the Chevron deference in an attempt to defend that interpretation. And under Chevron deference, typically it's a problematic deference that requires courts to defer to administrative interpretations of language that are ambiguous. But here, the court rejected applying Chevron and adopted our definition of foreign language, meaning a language that's foreign to the United States. And by our definition, Spanish and Arabic are foreign languages, regardless of whether someone grew up speaking that language or not.
Tell me if this might be a fair way to say it. I mean, it's not so much that the judge refused to apply Chevron, it's that in applying Chevron, he decided that the statute wasn't ambiguous. So essentially, he ruled for our client at Chevron step 1 and never reached Chevron step 2, which is what you do in the event of ambiguity, which that's when you would tend to defer to the agency's reasonable interpretation. But here he just said, you guys are right on the statutory interpretation question, and so we never get to the issue of deferring the way the agency wants us to.
That's right. And a lot of the problem with Chevron comes from the step 1 analysis where, you can always, the agency can always conjure up something to create the idea of ambiguity. And here the agency's argument was, well, if we're trying to promote a foreign language, the agency conflated promote with acquire and said, well, the point of this fellowship should be to encourage you to acquire new languages from U.S. schools, as opposed to encourage you to maybe develop further training in a language you already spoke growing up. And that was the agency's basis for ambiguity, which the court did not accept because applying a Supreme Court precedent from a few years ago called Kaiser, the court, in a welcome way, exercised its own judgment to construe the statute to determine whether there's an ambiguity rather than defer to the agency. And there are multiple parts of the statute that says, well, this fellowship is meant to bridge, connections and relationship between the United States and other countries, and to, encourage the study abroad in other countries of their culture and language. And so based on that context, the court interpreted foreign language to mean whether a language is foreign based on, a country-based definition of foreign, as opposed to an individual applicant definition of foreign.
And I should give credit here to Judge David Guaderrama of the U.S. District Court for the Western District of Texas. He's the one who granted our client Veronica Gonzalez's motion for preliminary injunction. So what happens now that the motion has been granted, Sheng?
So the court actually vacated the regulation that we're challenging that disqualifies someone from using their native language. And it's interesting, we actually differ with the agency with respect to what that vacator means. We interpret that vacator to mean that the agency can no longer, disqualify someone based on their native language or penalize them in any way. The agency curiously has interpreted the order to vacate the entire evaluation of someone's foreign language proficiency, which seems incongruous with the statute, which requires the agency to promote the training in the modern foreign language. So you would think that whether someone speaks a foreign language should weigh, at least somewhat, should be meaningful in that evaluation.
Because right now, Sheng, Shane, just to put a fine point on it, I know no foreign language with any facility, and I will get the same amount of points from my foreign language skills as any of our clients will if I take the test, right?
Yes, exactly, and that's a really strange outcome, and we think it's not congruent with what the statute requires. So I think the next step for us is just to file a simple motion to get the court to clarify the scope of its injunctive relief. And you know, your common sense understanding of this is really it really strikes at the heart of this dispute, John. For example, the court, you know, conjured a hypothetical of you know, someone who speaks English, a Brazilian American who speaks English and Portuguese, you know, growing up, and at a job interview, and if the interviewer asks that person, what foreign languages do you speak in America? That person's going to reply Portuguese. You know, but under the department's definition, that person, because Portuguese is not foreign to that applicant, the reply would be, I speak no foreign languages, which seems just out of sync with how common usage of the term works in our society.
Absolutely. Do you think that the Department of Education is going to appeal this case to the Fifth Circuit, or are they just going to go back to the drawing board on the regulation here?
I think they're going back to the drawing board, and actually, because of an earlier motion for preliminary injunction we filed about a year ago, they've already agreed to revise the regulation here, and they proposed that the revision a few weeks ago. And the reason why our case is still going forward is because they proposed it, the rulemaking is so late that it's not going to benefit the 2023 applicants, including our client, Ms. Gonzalez. And so what we had to do is actually proceed further in court and get a court order to stop the department from using the regulations that they agree should be revised.
That's all the time we have now, Shane. But congratulations on your victory, and we look forward to seeing what really happens with the new regulations. Welcome back to Administrative Static. John and I are pleased to have with us for a repeat appearance Clegg Ivey, our Director of Engagement here at the New Civil Liberties Alliance, to update us on how things are going in the King George III Prize competition. For those who were with us 2 weeks ago, the King George, or maybe I should say for those who weren't with us 2 weeks ago, the King George III Prize it's the March Madness that people really care about, Clegg. This is the bracket. Started out with 32
runaway bureaucrats.
There you go.
Let's be clear. They're the administrative state, the executive branch folks. Yeah, I
almost said the worst of the worst, but I don't want to leave anybody out. We might have missed one that's really terrible, but at least 32 people who deserve to be criticized for something that they did to violate civil liberties in 2022.
We did have to limit it to 32, Mark. Although those of you who have been with us for a couple of years now know that the very first year we did this, we had 32 federal and 32 state. We had a 64 team bracket,
full bracket.
That was right in the middle of the lockdown.
Hopefully that won't happen again. So tell us. So we've gone from the 32 down to the sour 16. Any surprise upsets in the first round?
We've got upsets, Mark. You want upsets? We've got one. So I was shocked that Pete Buttigieg did not advance to the first round, and this, I think, has everything in the world to do with how much Lina Khan, the chair of the FTC, has gotten media for her recent flagrant decisions to really stretch antitrust law well beyond what Congress ever intended.
Yeah, she's so bad that the career bureaucrats at the FTC are leaving in droves because they don't want to be associated with this overstep.
Absolutely, career bureaucrats and other commissioners of the FTC are saying I can't in good conscience serve under Lina Khan because I can't be associated with the project she has here. It is so obviously lawless.
Yeah. So do you think she will advance again into the next round, or?
Well, I think there's a good chance. So Lena Khan faces off against Douglas L. Parker of OSHA, and if he were facing off against her last year, I think he would probably come out on top.
Yeah, this is when OSHA had the vaccine mandate that they were trying to propound.
Absolutely, but as we know, the Supreme Court smacked the OSHA mandate back. Major questions doctrine came through for us on that one
right at the beginning of 2022.
It happened so long ago, but this was last year. So I think it's been long enough that I think Lena Khan has a real good chance here to move on. At which point she will probably face off with. Well, she'll definitely face off with either Richard Cordray, the architect of the student loan debacle, or Erica Y. Williams of the PCAOB. And honestly, now we're talking about upsets. Erica Y. Williams. Are you familiar with Mrs. Williams?
I'm familiar with the Public Company Accounting Oversight Board, PCAOB or Peekaboo, but I was not familiar with Erica Williams per se. No.
So I think I want to say that NCLA is part of the reason why the PCAOB or Peekaboo is getting more press. And Peekaboo beat Gina Raimondo, Secretary of Commerce. Now that's Commerce is a big department. I consider that an upset, Mark.
Yeah. Any other first round upsets or notable failures to advance?
Well, probably the one other upset that I would point out is that Vivek Murthy, the Surgeon General, somehow beat out Martin J. Grunberg of the Federal Deposit Insurance Corporation, FDIC.
So people didn't just consider there wasn't a recency bias here.
I assumed there would be, Mark. I thought, FDIC is gonna steamroll the first round, but nope. Congratulations of a sort to Vivek Murthy. There's another upset for you.
Yeah. Well, maybe people really looked at what Grunberg did in 2022 and said, well, maybe he was asleep at the switch, but other people did things worse than sleeping at the switch.
Or the voters have a lot of bank accounts over $250,000.
Vec,
they love him.
I thought about that. They really don't want to upset him. They need him to be in a very generous mood, which, by the way, is something that happens in a tyranny. You have to be nice to your overlords because they control your life, and in this case, your deposits.
Well, your bread and your circuses.
Indeed. So, Mark, I wanted to say, in addition to the upsets, there's something really interesting about the people that advanced this year.
Oh, great. Tell me.
Of the Sour 16, almost 1/3 were involved in what is being called the censorship industrial complex. And that is something that NCLA has been on the cutting edge of. We have been pursuing the state's desire to censor its citizens whenever they speak in a way that is contrary to whatever the government line or propaganda is. Now, these people specifically, I'll just give you a few. You've got Rob Flaherty, the White House Digital Communications Director, who was
over these emails.
He spearheaded the Twitter censorship. Vivek Murthy, I already mentioned, the Surgeon General. Elvis Chan, the FBI agent out in the San Francisco field office, who was basically single-handedly responsible for why all of that talk about Biden's son and all of these things were deleted from the internet, deleted from Twitter, and people were deplatformed.
And his deposition in our lawsuit is really what blew the doors open on that story.
That's right. And then you've got Gavin Newsom, who I'm counting as one of the censors. NCLA has sued
him over censorship.
That's right. Trying to shut doctors up, threatening to take away their licenses if they say things give advice to their patients that the government doesn't like. So I think, if you go back and look at the people who advanced in previous years, there was a heavy dose of COVID overreach.
Yeah.
And now it's something more specific. It's censorship.
Would you include Merrick Garland in that group as well?
I would. Yes, that's how I got to 1/3 of the roughly 1/3 of the Sweet 16. So 5 of the Sour 16. If you include Merrick Garland, and I certainly do, then you've got a bunch of censors. Yeah.
Yeah, absolutely. Well, and I think perhaps the Biden administration would take pride in the fact that there's real diversity in this bracket. I mean, we have 4 women administrators who are here. We have a number of minority administrators in this list. So it's not just white men who are responsible for violating your civil liberties here.
Well, the downside of diversity is that the blame starts to be spread around, and it's really, really hard to only blame the white males. So, yeah, you're right. Now, look, I mean, we have our share of white males. I mean, Richard L. Trumka, the man that wants to single-handedly take away your gas stoves, he advanced, and so you've got that staring you down. And then I think Gary Gensler, the chairman of the SEC, SEC. I mean, I think, John, what percentage of our lawsuits are against the SEC?
It's certainly a lot. Certainly since Russ got here. But yeah, so we've had trials against them. We've brought all kinds of suits, and we're commenting on all of their schemes on ESG and all the rest of it. It's just one thing after another with them.
I think,
and I don't think it says too much to say that stay tuned, SEC. There are more in the pipeline.
Yeah, the thing about the SEC is that whereas a lot of these other folks, there's basically one issue we have with each of these agencies in a lot of cases. But the SEC, you're looking at due process, you're looking at First Amendment. It just doesn't. Hits keep coming.
For the recidivism alone, Gary Gensler probably ought to advance. Although that's a tough matchup going into the next round. Margaret Cook from the Massachusetts Department of Health, she's the one largely responsible for downloading 1 million COVID tracking software downloads onto folks' phones in Massachusetts.
Absolutely. So imagine yourself a resident or just someone who just got off the plane in Boston. In Massachusetts, and you suddenly there's an app on your phone that you didn't put there. The government put it there without your permission, without your knowledge, and it's now tracking you. All in the interest of it's just for your own good.
Not just plain if you're driving through to go to Maine.
That's right. That's right. So it wasn't just citizens. It's just any person who found themselves, unfortunately, near a certain set of cell towers. And they had and this spyware was put on people's Androids. I think, honestly, Mark, if you want somebody who might go a lot further than people, the more we tell
like a
people,
sleeper pick,
the more people
Dark
find
horse.
out what this woman did, the angrier they get.
What I always say is in 49 states, the app was available if you wanted it. But in Massachusetts, it was mandatory and you didn't know it.
It was available if you wanted it or not.
Exactly.
Yeah, I always like to
It
make
was
the
made
joke.
available to you.
Yeah, I like to make the joke that they had Bono as their advisor. Those of you who remember a few years ago, we had to we all got the U2 song on our phones without our knowledge or anything like that. So so look for Margaret R. Cook to advance. She's my sleeper pick.
Okay. Anything else that you wanted to share with us about the bracket as it goes forward here?
Just a couple of things. We normally have more governors advancing beyond the first round than we had this year, and I think if you look at these the Sauer 16, I believe only Gavin Newsom has survived. So I think that's a good thing, Mark, because in the past the governors dominated. In the last few years, the governors have been dominating these the second and third rounds, and I think this year maybe that's a sign that the people in the states have pushed back against some of this this power grab that we've seen.
Well, a lot of them lost in November, so there is that.
That's a good point. That's a very good point. So I'm happy there is good news here. From year on year, you see, hey, fewer governors. Now the bad news is, boy, there's a lot of censors.
Yeah, there really are. So how do people vote if they want to? It's not too late to get involved here. If folks want to jump in and vote and help determine the elitist 8. How do they do that?
All right, there are a couple of ways to find it. First of all, you can vote on Twitter. So we are just look for New Civil Liberties Alliance or NCLA on social media. We post polls, so you can find those and you can vote in those polls. But you can also just Google King George III NCLA, and the first thing that comes up, I'm proud to say, is our page that tells you all about the contest and tells you exactly how to vote.
What if you use Bing or DuckDuckGo?
You know what? It's good on every search engine because there just isn't anyone else doing what we're doing. So that's the benefit of being unique.
Yeah, absolutely. And so when can folks find out who finally wins the King George III prize? When will that be announced?
Well, that's a great question. We're going to be announcing the champion, the winner, at our King George III award ceremony, the Georgies, we're calling them. And that'll be on June the 1st, 2023. So right at the beginning of the summer.
Fantastic. So we've got the Sauer 16, then we'll have the elitist 8, and then what comes before the champion?
The flagrant 4.
The flagrant 4. I love it. That's keeping with the basketball sort of analogy there as well.
We might actually do the illegitimate 8 instead of the elitist 8. But last year it was.
Well, thank you so much, Clay, for updating us on this, telling folks how to vote. We'll have you back to get another update here as the field trends.
Always a pleasure.